My name is Kristal Bowman-Carter. My last name is spelled Bowman-Carter.
What do you do for work?
I'm an attorney.
What kind of attorney are you?
I focus on estate planning and a little bit of business work.
How long have you been doing estate planning?
I have been licensed since 1996 to practice law, but I've been doing estate planning almost exclusively since 2012.
And do you do that practice here locally?
Yes, I have an office in Park City.
Approximately how many estate plans have you drafted in your practice?
1,400, 1,500.
Did you know Eric Richins?
Yes.
How did you know him?
I did some work for him.
What kind of work did you do for him?
I did 2 projects for him. First, I did a buy-sell agreement for him and his partner for their business, C&E Stone Masonry. And then I did his estate planning.
Did you meet with him in person?
Yes.
How many times?
At least 4.
Okay. Did you know Kouri Richins?
I know of her. I've talked to her on the phone once the day that Eric died.
I want to talk about the first legal project that you did for Eric Richins. You mentioned that was related to his business, C&E Stone Masonry. Is that right?
Correct.
When did you complete this agreement, or when did you work on this project for him?
I was first contacted in June of 2018 by his financial advisor. We got the ball rolling. I gathered information, and then we ended up signing it almost a year later, June 25th, 2019.
Okay. In general, explain to the jury, what is a buy-sell agreement?
A buy-sell agreement is a contract between owners of a company that sets out the terms in advance, what will happen when there is a transfer of a business interest, whether it's by sale or because of an owner's disability or their death.
Are buy-sell agreements, in your experience, are they common?
Yes.
If we could show the witness Exhibit 4-2, please.
Apologize. We'll fix that. Scott, if you unplug for me. You should be able to see this.
I can see it.
Okay.
Do you recognize this document?
Yes.
And what is it?
It's the C&E Stone Masonry LLC buy-sell agreement that I prepared.
Okay. I'm going to move to admit 4-2.
Ms. Lewis, Mr. Ramos. Oh,
No
Ms.
objection,
Neptune.
no objection, Your Honor.
Okay. States 4-2 is admitted.
If we could publish this and move to Article 3, please. What's contained in Article 3 of this agreement?
Article 3 provides what happens if one of the partners or owners of the company were to die.
And essentially, what does it say in non-lawyer speak?
Well, the mandatory cross-purchase agreement provides that if one of the partners dies, either Eric or Cody, then the decedent, the person who has died, their estate has to purchase the business interest from the surviving partner using life insurance.
And is that the life insurance was what was used in this buy-sell agreement?
Yeah, so this buy-sell agreement used 4 different $1 million life insurance policies. Each of Cody and Eric had 2 $1 million policies on the life of the other, and if one of them were to die, they had to use that money to purchase the interest in C&E Stone Masonry from the estate, so that the survivor could continue to control the company and run the company.
Is that a pretty common
Yes.
thing in buy-sell agreements?
Excuse me.
That's
Yes, it
great.
is.
I want to move now to talk about the second project that you did for Eric Richins. You mentioned that was a estate planning
Yes.
project. Was that did that take place in October of 2020?
Yes, he came to see me. He called my office on October 5th and came to see me on October 13th, 2020.
And so what was the purpose of that meeting?
It was to update his estate plan and revoke a prior power of attorney that had been abused.
When we're talking about an estate plan, what are the main documents that come out of an estate plan?
So the basic estate plan that everyone needs is a will, a durable power of attorney, and a health care directive. And sometimes, most of the time in my practice, you also need a trust to avoid probate and to protect the beneficiaries of your estate plan from themselves or from others.
Okay. In preparation for that meeting with Eric Richins, did he fill out some paperwork before and during that appointment?
Yes, I have all of my clients fill out an intake worksheet, gather information about their priorities and their assets. He partially filled it out, brought it in with him to our meeting, and then we filled out the rest together as we discussed what needed to be done.
And these intake worksheets, how is that something that your firm uses with every client, or how does that work?
Yeah, either my office manager or my receptionist sends it out to everyone. It's something I can't really function without.
Okay. If we could show the witness 4-9, please. And go ahead and scroll through it so she can see the whole thing. Do you recognize this?
Yes.
And what is this?
That's my estate planning worksheet filled out by partially by Eric and partially by me.
Okay, I'm going to move to admit 4-9.
No objection.
4-9 is admitted.
Now, if you could take that binder in front of you and turn to tab 9. Is that the same exhibit that we're looking at in 4-9?
No.
Okay. Which one is that?
You're having me look at the healthcare directive.
Oh, I see. We'll come back to that one. I had it labeled wrong. Before creating Eric Richins' estate plan, did you review a premarital agreement?
I reviewed it the day before he signed his estate plan.
Okay. If we could, 4-1 is the premarital agreement. That's already been admitted. If we could publish that, please, and go to section 1. And paragraph 5. So this is the document, the premarital agreement that you reviewed. What
Yes.
does paragraph 1, section 5, again, the non-lawyer version, what does this say?
So what it says is that C&E Stone Masonry would remain Eric's separate property to dispose of as he wished during his life after his marriage to Kouri Richins.
And if we could go to section 2, please. What does this section of the premarital agreement deal with?
Again, it deals with Eric's separate property, that C&E Stone Masonry will remain his sole and separate property, even if they commingle marital funds, except that if he were to die, then his interest in the company would pass to his wife, which is Kouri in this document.
Okay. And if we could go to section 3, please. And how about this section? What does this?
So that section addresses primarily Kouri's rights in C&E property that she might have under the law at Eric's death. Can I elaborate on
Sure.
that? Okay. So if you don't have a premarital agreement, then you have rights in your spouse's estate. And when you're a nuclear family with no children from a prior marriage as they were, that means that if your spouse dies, you are entitled to at least 1/3 of the augmented estate. In other words, everything that passes to anyone as a result of your spouse's death. And this paragraph, the section 3, paragraph 1, says that Kouri is giving up her right to that 1/3 as it concerns C&E Masonry, Stone Masonry.
So I want to turn your attention now to that actual meeting that you had with Eric Richins in October of 2020. What was he there to accomplish? Why was he in your office?
He was referred to me, I'm not sure if it was from Christina Miller or Brian Freckleton, referred back to me. I had worked with him again to update his estate planning based on some recent financial malfeasance and some concerns that he had for his sons, that if something were to happen to him, they wouldn't receive or be cared for financially with his assets.
When meeting with Eric Richins, was there something unique to you or something that you did for the first time in preparing his estate plan?
Yeah, there were a few things.
What were those?
So, one, he didn't want us to communicate with him by email. That happened a little bit later, but because he was worried that Kouri would be reading his emails. Two, he wanted to leave everything to his kids if possible. And at the beginning of the representation, I hadn't seen the premarital agreement. He wasn't sure if it existed, but eventually, communicating through his sister, as he instructed, we received the premarital agreement and saw that it unfortunately did not address all of the property. It only addressed C&E Stone Masonry. So for that reason, for the first time ever in my career, I had to draft around that augmented share. So we provided at a minimum that there would be a share created for Kouri consisting of one third, the amount she would be entitled to. And the rest passed directly to his kids. That also applied to tangible personal property. He said that all of his tangible personal property, things you can touch and feel, like your furniture, your jewelry, your collections, would pass directly to his sons, who were all very young at the time. And that's unusual. It usually passes directly to the spouse. I think there was one other thing, but I'll come to it.
If it comes to you, let me know.
Mm-hmm.
So I want to turn your attention now to those estate planning documents that you referenced that you prepare when doing estate plans for most people. And for Eric Richins, did you prepare a living will?
A living will, a healthcare directive?
Yes.
Yes.
And did you also prepare a trust?
Yes.
Okay. I want you to take a look at Exhibit 4-11. We'll put it up on the screen for you. And if you could scroll through it, Scott. Do you recognize this?
Yes, that's the will I prepared for Eric Richins.
And then if we could show the witness 4-12. Do you recognize 4-12?
Yes, that's the trust I prepared for Eric Richins.
Now, in the book you have in front of you, I'm going to ask you to turn to tab K, or to tab 6. Is that the will that we just saw in the same exhibit?
Yes.
And there's a signature as a part of that document. Is that correct?
Yes.
And who is that document signed by?
The document was signed by Eric Richins on page 8, and his initials appear on every single page of the document.
And you notarized that document, right?
I witnessed and notarized the document.
If you could turn to tab 10 in that binder. Is that the trust document that we just saw?
Yes, it is.
And is that document also signed?
Yes, it is signed. It's signed by Eric Richins, and I notarized it.
Okay, and that means you saw him sign it in front of you, right?
Yes, you have to. If you're a notary, you're required to be there in person to witness somebody signing something before you can attest to their signature.
And then also on tab 9, you told us that was the healthcare directive. Is that right?
Yes.
And is that document signed?
Yes, it is.
And similarly, did you see Eric Richins sign that?
Yes, I did.
Okay. I'm going to move to admit 4-11 and 4-12.
No objection.
4-11 and 4-12 are admitted.
If we could put up 4-11, please, and publish to the jury.
4-11's up.
And so this is the will you described that you prepared for Eric Richins. Is that correct?
Correct.
I want to go to section 7.03, please. What does this section provide for?
That's the section where Eric expressed his intentions for the disposition of his remains. He wanted to be buried upon his death.
Now, talk generally about this document and what kind of legal implications, this document has.
So in the case of a trust-based estate plan, which is what we prepared for Eric, the will is not usually as important as the trust. All of his directions for what he wanted to happen to his assets and the protections he wanted to put in place for his loved ones were contained in the trust. You still have to have a will. It's called a pour-over will. It says that if I leave anything out of my trust, if I forget to make a beneficiary designation when I die, give it to my trust to be controlled by the terms of my trust. And then I always include either burial, cremation instructions if somebody has a preference. Sometimes people don't have a preference, then I don't say anything. Anything that's governed by a will has to go through a process called probate. That's a court-supervised process of administering an estate, the non-trust assets. So when you draft a trust-based estate plan, or when you execute a trust-based estate plan, the idea is you're avoiding probate. You don't need to use the will. It never has to go through probate. The will is just a backup document.
So now if we could put up 4-12, please, for the witness. And we can publish this as well. So talk about, in general, how a trust works.
Okay, so a trust is a contract between, and I'm going to use Eric specifically because this one was prepared for him. It's a contract between the party who drafts it, the party who's going to benefit from it, and the party who's going to administer it. So initially, a trust is a contract between you, me, myself, and I. Eric was the grantor. He created the rules for the trust. Eric was the trustee. That means he was the manager of the trust, of all the assets that were contained in the trust, and had to follow the rules that he set. And then Eric initially was the beneficiary until such time as he became, until he died. He was the trustee until such time he became permanently incapacitated or died, and then somebody else would manage those trust assets. It's like a box that you have rules for. You put the assets in, and those rules control all of the assets in the box.
So you mentioned that a trust, the trustee was Eric while he was alive,
Yes.
and then he chose someone else to be a trustee in the event of his death. Is that correct?
He did. That would be at Article 3.
Okay. Who did Eric choose as his trustee?
He chose his sister. Well, he chose a couple of successors. His sister, Kouri Richins Benson. And then I want to see who he chose as this. And then I'm looking at the will still.
That's okay. You don't have to look at it. If you don't remember, that's okay.
No, it was Katie that he chose as his first successor trustee, and I believe it was Clint as the second.
What is a trustee?
The trustee is the person who has legal title to the assets in the trust and is charged with managing those assets for the benefit of the beneficiaries of the trust in the way that the trust says.
In your experience, was it unusual for someone who was married to not choose their spouse as a trustee?
Yes.
What effect did the trust have on Eric Richins' property?
While he was alive, he could still do anything he wanted with the trust assets because it was a revocable trust. But the trust owned his property in that little box. And the effect was that when he died, it became irrevocable, and those assets had to be administered according to the terms of the trust that he set.
Scott, if we could go to Article 8.01 of the trust.
Excuse me.
Describe for the jury, in layman's terms, what this section of the trust means as it pertains to Kouri Richins.
Okay. Might be a little wordy here. So on
Do your best.
On Eric's death, this trust became irrevocable and sub-trusts were created. A trust for Kouri called the Q-tip trust that you see here at Article 8, and then the next trust is the descendants trust that was for the benefit of the kids. Because it was a Q-tip trust, the law requires that all of the income generated by the assets held in that share must be distributed to Kouri during her lifetime.
So did the trust provide for Kouri Richins' household expenses?
Not specifically, but there's another, the guidelines for distribution also provide that she's entitled to also access the principal through the trustee for her health, education, maintenance, and support. So yes, she was provided for, just not household expenses specifically.
And you mentioned that a trust is like a box that someone can put their assets into. What were some of the assets or the assets that went into Eric Richins' trust?
So the easiest thing we did was he signed an assignment of tangible personal property. So things that don't get titled anywhere, like your furniture, your jewelry, those collections. By signing that document, that transferred those things to the trust. I prepared a deed for him for the house that he owned in his name, and we transferred that asset to his trust. I think the house was on Willow Court. And then I prepared an assignment of interest in C&E Masonry that he signed later on in February. After the trust was built, then we could put the things in it, and he signed that in February of 2021. Put that in the trust, and also another LLC interest.
Scott, if we could go back to just the first page of 4-12, please. Even the title page for, yeah. So that document has a date on it. What's the significance of that date?
That's the date that Eric signed the trust, and for titling purposes, we include the date in the name of the trust.
And so, for all intents and purposes, that's the effective date. That's when it becomes legally in effect.
That's when it becomes legally binding, yes.
If we could show the witness 4-14, please. Do you recognize this document?
I do.
Did you prepare it as part of Eric Richins' estate plan?
Yes, it's the power of attorney that I prepared for him.
I'll move to admit 4-14.
No objection.
4-14 is admitted.
If you could explain, you mentioned that this is a durable power of attorney. What is a power of attorney?
It's a document that nominates an agent, somebody that you choose, to manage your property if you become incapacitated, or sometimes immediately.
And what effect did Eric Richins' power of attorney have on his estate plan, or who did he choose as his power of attorney?
I'm sure he chose Katie Richins Benson.
Okay, if we could show the witness, I don't want you to look at anything just yet. If we could show the witness 4-13, please. Do you recognize this document?
Yes.
What is it?
I'm scrolling through it. It's a draft revocation of a prior durable power of attorney.
Is this also a document that you prepared for Eric Richins?
Yes.
I'm going to move to admit 4-13.
No objection.
4-13 is admitted.
If we could publish 4-13 to the jury, please. So this was a document that you drafted as part of Eric Richins' estate plan, is that right?
Yes, I drafted it, and then you can see that there's the prior durable power of attorney is attached as an exhibit.
Okay.
I didn't draft the prior power of attorney.
Certainly. Was this document ever recorded?
This version of the revocation of durable power of attorney was never signed or recorded.
Do you know why?
Eric was concerned about the repercussions he would face if he told Kouri.
Object to hearsay, Your Honor.
That was my impression.
Pause. Please approach. Jury, I appreciate your patience. You cannot consider what Eric Richins said to Ms. Bowman-Carter.
And so I'm not sure if your answer was heard by the jury. I won't ask you why, but was this document ever recorded?
No, this document was never recorded.
Okay. Now, you mentioned earlier that you were communicating with Eric Richins' brother-in-law, I believe.
I had communications with Eric Richins' brother-in-law, yes.
And you were instructed to only communicate with the brother-in-law, is that right?
I was instructed to communicate with his sister, and I was given I believe it was a shared email account,
Okay.
and they both responded there.
Was that unusual in your practice?
It was the first time anyone had asked me to do that, so yes.
Okay. I now want to turn your attention to the week that Eric Richins died. Did there come a time when you learned that Eric Richins had died?
Yes, I learned that day that he had died, March 4th, 2022.
And is that when you became aware of it, or was that a day later?
I believe I learned the day that it happened.
And how did you learn about Eric Richins' death?
Clint Benson called me and told me that he had died.
And did you also receive a call from a sheriff's deputy that day?
Yet later that day, I received a phone call from somebody who identified themselves as the sheriff's deputy, and who asked me to talk to Kouri.
And did you talk to Kouri on the phone that day?
Yes.
What did you tell her?
Apparently, she was upset about the house, and I was asked to explain that there was an estate plan in place and that the house belonged to the trust, and that's what I told her.
When you were explaining to Kouri Richins that the house belonged in the trust, how did she react?
Oh, not positively. She was livid. She was upset, and she said, "What is wrong with you people?" and handed the phone back to the officer, I believe.
When having this conversation with Kouri Richins, was it your impression that she was unaware of the estate plan?
Object to speculation, Your Honor.
I'll lay a little foundation.
What could you tell from your conversation with Kouri Richins about her knowledge regarding what would happen with the house?
She told me that the house she told me the house belonged to her. She thought the house was hers, and obviously, if she thought that, then she was unaware of the estate plan and that the trust owned the house.
When were you contacted by an attorney representing Kouri Richins?
Yeah, a bankruptcy attorney reached out to me.
Objection, Your Honor. Can we approach?
Sure.
So you mentioned that you received an email from an attorney representing Kouri Richins. Is that right?
I received an email on March 8th from an attorney that said he represented Kouri Richins.
Okay. What, and so, sorry, I missed the date that you said. He contacted you on March 8th, is
March
that right?
8th, 2022.
What was the general nature of that email?
Just to tell me that he represented her and to ask that we give her time to grieve, don't act too quickly, so that she could attend to services, and I believe that was it.
And so he was contacting you in reference to the estate plan, is that right?
Possibly. I'd have to look at the email, but I don't even know if he referenced the estate plan.
He was talking about the house that was in the estate plan, is that right?
Yes.
Did you, after that email exchange on March 8th, did you provide any documents to Mr. Nate?
Yeah, it was Attorney Nate, and I did provide him with a full copy of the estate plan. I pointed out several things, including that the will called for burial and asked.
Yeah, go ahead. You can finish.
And asked and because I had become aware that Kouri was seeking to have his body cremated, so I wanted to make
Objection to hearsay and non-responsive.
Well, taking them in reverse order, overruled, and it's unclear, so I'll sustain it, lay some more foundation.
Sure. So one of the documents that you provided to Mr. Nate was the will. Is that correct?
That's correct.
And one of the reasons you provided him the will was so that he was aware of Eric Richins' wishes as it concerned his burial.
Yes.
Did you open probate on Eric Richins' estate?
Yes.
When did that happen?
March 14th
Of 2022?
Only 10 days after Eric's death.
In your experience, is that, first, I'll ask two questions about opening probate. Was that a typical time frame for those events to happen?
No, that wasn't a typical time frame.
What do you mean by that?
Well, a couple of reasons. Usually people need to get through the services and grieve a little bit. If the property is secure, there's no reason to open probate right away. But in this case, Eric had a fully funded trust. I never would have opened probate if we were just administering the trust. That's the whole reason you have a trust, is to avoid having to go to court, make everything public.
And so when you're saying the time frame was not typical, it was quicker than usual. Is that fair?
Yes, it was much quicker than usual. And with a trust, I just wouldn't have opened probate. If at all, I would have opened probate a year after the death, after creditors' claims had been cut off.
And so you opened probate quickly because there was some urgency, in your view?
Yes. Eric had... Can I explain why?
Please lay some foundation for how she knows whatever she's about to say.
Well, sure. Did you... Can we approach? I don't want. So you mentioned that you received an email from an attorney representing Kouri Richins. Is that right?
I received an email on March 8th from an attorney that said he represented Kouri Richins.
Okay. What, and so, sorry, I missed the date that you said. He contacted you on March 8th, is
March
that right?
8th, 2022.
What was the general nature of that email?
Just to tell me that he represented her and to ask that we give her time to grieve, don't act too quickly, so that she could attend to services, and I believe that was it.
And so he was contacting you in reference to the estate plan, is that right?
Possibly. I'd have to look at the email, but I don't even know if he referenced the estate plan.
He was talking about the house that was in the estate plan, is that right?
Yes.
Did you, after that email exchange on March 8th, did you provide any documents to Mr. Nate?
Yeah, it was Attorney Nate, and I did provide him with a full copy of the estate plan. I pointed out several things, including that the will called for burial and asked...
Yeah, go ahead. You can finish.
And asked the, and because I had become aware that Kouri was seeking to have his body cremated, so I wanted to make
Judge, hearsay and non-responsive.
Well, taking them in reverse order, overruled, and it's unclear, so I'll sustain it, lay some more foundation.
Sure. So one of the documents that you provided to Mr. Nate was the will. Is that correct?
That's correct.
And one of the reasons you provided him the will was so that he was aware of Eric Richins' wishes as it concerned his burial.
Yes.
Did you open probate on Eric Richins' estate?
Yes.
When did that happen?
March 14th
Of 2022?
Only 10 days after Eric's death.
In your experience, is that, first, I'll ask two questions about opening probate. Was that a typical time frame for those events to happen?
No, that wasn't a typical time frame.
What do you mean by that?
Well, a couple of reasons. usually people need to get through the services and grieve a little bit. If the property is secure, there's no reason to open probate right away. But in this case, Eric had a fully funded trust. I never would have opened probate if we were just administering the trust. That's the whole reason you have a trust, is to avoid having to go to court, make everything public.
And so when you're saying the time frame was not typical, it was quicker than usual. Is that fair?
Yes, it was much quicker than usual. And with a trust, I just wouldn't have opened probate. If at all, I would have opened probate a year after the death, after creditors' claims had been cut off.
And so you opened probate quickly because there was some urgency, in your view?
Yes. Eric had... Can I explain why?
Please lay some foundation for how she knows whatever she's about to say.
Well, sure. Did you... Can we approach? I don't want.
Ms. Shervnak, please proceed.
Without telling us any specific statements or what anybody said, why did you open probate so quickly?
I needed to get the nominated personal representative in place so that she, Kouri Richins Benson, would have the ability to manage the probate estate and make sure that Eric's wishes, as expressed in his will, were followed.
Thank you. And I neglected to check. Have I admitted Exhibit 4-14? I know I talked about it with this witness. Did we?
I'm sorry, wrong one. No, it wasn't there, Your Honor, without
Okay,
objection.
I just didn't have a note there, so I wanted to make sure I admitted it.
Ms. Nestor is correct. It's been admitted without objection.
Those are all my questions.